Okay, we're talking now about title deeds ownership restrictions. First of all, we want to explain the difference between legal ownership, legal title, and equitable title. Legal title is a legal concept signifying ownership of a collection of rights called a freehold estate, and it comes in two forms: fee simple estate, life estate. When we say we have title, we often mean we have ownership of. I have title to this property, I have ownership of this property. Then we have equitable title. This interest implies the person will receive legal title in a future date. At a future date, the interest that a buyer receives upon executing a contract prior to title closing, for instance, is an example of this. Just to explain it, if I have a deed in possession that I own the home, then I've got title. That's legal title. But how about we've got a buyer and a seller? They're just about to write a contract between the two to purchase the house. So the buyer presents the contract to the seller, offer to purchase, and the seller accepts it. So now that buyer has got a contract, and that means that that buyer has got some interest in the property. Equitable title, as he expects to get legal title sometime in the future. So that means the seller cannot sell to anybody else or change the terms of the contract without permission from the buyer. When we actually change ownership, basically what we're doing is we're alienating ourselves from the ownership. The act of transferring ownership or title and interest in real property. Alienation may be voluntary, with the owner's control and consent, or involuntary, without the owner's control or consent. Transfer by voluntary alienation is usually accomplished by deed. It's a written instrument used to convey an interest in real property. It conveys legal title. Or it can be through a will. When you die and you own a property, a dead person cannot own property. Died testate, that means they died with a will. Person who has a will, the male is a testator or a female testatrix. So the person will leave in the will the property to someone. This property in legal terms is called a device, and the person to whom it goes is a devicee. We also mention in the book that if it's personal property left in a will, that is a bequest, and the person receiving the personal property is a beneficiary. Okay, we now have transfer by involuntary alienation. Descent. When a person dies without a will, this is called intestate. The property will descend to any known found heirs as found by the probate court. Escheat will provide for the government to take the property. If after the person has died, the court cannot find any heirs to hand over the property to, then the state will take it. And that solves the problem of a property not having an owner. Adverse possession is when the true owner sleeps on the owner's rights, doesn't actually use the property, has no care for the property, and somebody else goes in and uses it for a specified period. We talk about that a bit later. An eminent domain gives the government the power to take a property for public purpose through a legal process called condemnation. We talk about that a bit later. What we want to look at is the conditions for adverse possession. This is a bit of a strange one, but basically, if this farmer is using this field and living in the buildings on the field with no objections from anybody, the owner hasn't come and turfed them out, hasn't given them permission, but if he does it openly, doesn't hide, you have to occupy open possession, and you go down to the courthouse and pay the taxes, and everybody can see that you're there. Then after 7 years, you can actually go to the court and claim title to the property. This is called adverse possession. Eminent domain, the way I remember it, is through a process of condemnation. If the state or the local government or whoever decides they want to either take your property or a part of it, maybe the front of your yard because they want to widen the road, or maybe because it's an old derelict building which has been deserted by the owners maintenance-wise, then they can come along and say, listen, we need this, we're going to pay you a fair price for the building, must be for public use and good, maybe part or all of the property. And if you don't like it, then you're going to have to go to court to fight it. Eminent domain, and the process is called condemnation. When we actually perform any transactions, we usually like to have them recorded in the local courthouse so the whole world knows that this has taken place. If we don't, in other words, if we see something happen, we hear about it, or we know about it by any other method, we call this actual notice. And this is a bit hard to prove because there's no written documentation has been recorded. So we say actual notice is direct knowledge acquired in the course of a transaction by an act or verbal and so forth. Hard to prove in court. So what we do whenever we have something we want the whole world to know about, like deeds, mortgages, liens, births, deaths, marriages, divorces, bankruptcies, anything you like, we go along to the courthouse with the document that performed this transaction. But before we do that, the document has got to be acknowledged. Acknowledgement is a formal declaration before a notary by the grantor that the signing is a free act and it's done in front of two witnesses, one of which may be the notary. And that's how we normally do all documents associated with real estate. We give them constructive notice so anybody can go to the courthouse records and see what's going on. The next thing is we have to understand the chain of title. What happened to this house ownership chain before you bought it, before the person before you bought it, before the person before that person bought it, and so forth. A chain of title is a complete successive history. That can be very extensive because it goes back to the time when the property was first formed. Abstract of title, which is a condensed report of title search, which is found in public records. And then you have a title opinion executed by an attorney who has studied the abstract and decides whether the title is free and clear, marketable, but there's no guarantee. This is what it can look like in a courthouse. You have abstractors, researchers that go into the courthouse, can be done online now of course, and literally go and dig out the chain of title. And then they prepare maybe an abstract. Once again, this is an old-fashioned one, but here's a typical example of an abstracted title. The major parts of the property's ownership actually condensed down into an abstract. The problem is that this is only as good as the researcher and as good as the recorded documents. And therefore you don't have total protection regarding the true ownership of the property historically. And especially when an attorney gives an opinion, once again, it's not guaranteed. We need something to protect us in case there are errors or mistakes or omissions in the research. So a title opinion is actually executed by an attorney who has studied the abstract, and they would like something called title insurance to go with this. This is a contract that protects the policyholder from losses from defects in title. Florida does not require title insurance on conveyances of property, and most certainly licensees are not qualified to give opinion of a title. Just tell the parties to go and see an attorney or a title company. Licensees must first obtain a current opinion before passing that on. Even then, I think you're on dodgy ground. Don't do it. There are two types of title insurance. One is issued for the owner's policy, or issued to the seller, can be paid for by the seller or the buyer, but essentially what this does, it helps warrants any ownership defects from the seller may have previously to the original owner of the property years ago. It's issued for the purchase price, protects the new owner and the owner's heirs, not transferable from one owner to another, one-time premium paid at closing. If you're taking out a loan, the lenders usually need their own policy for the unpaid mortgage amount. So the lender's policy is issued to for the amount of the unpaid mortgage. So the value of the policy changes over time as the mortgage is paid off. It protects the lender against title defects. It is transferable to anybody who buys that mortgage from the original mortgagee. And protects lender up to the outstanding loan balance, and most lenders do require this before they give you a loan. One-time premium paid at closing, usually by the lender. Okay, we're just going to end that first part, and we'll carry on with the second part.